me one second.
Welcome to Wholesale Hotties, a place where ladies in real estate are talking about real estate. I'm your host and MC for the evening, Sharon Lee Smith, together with my co-host, Donda Molinix. Hey, Donda, and Monique Fell. Hi, Monique. How are you? And today's special guest is my one and only friend, Mary Hart. Mary, thank you so much for coming on the show today. I'm so excited to have you on.
Absolutely. Thanks for having me.
Absolutely. So, ladies, Mary is an amazing real estate attorney, been in practice for a long time. I'm going to have her tell you all about it. And she also then has pivoted to a hard money lending thing, as well as has a similar focus to us, has a ladies mastermind that she has. So we already interviewed Wendy Sweet about that. We'll have Mary talk about it as well. Mary, welcome to the show. Can you tell us a little bit about you? How long have you been doing this? What are you up to? What's going on?
Sure. Well, I've been an attorney for 34 years. I'm technically retired as an attorney. I'm licensed, but I'm not practicing. I've been a private lender for about 22 years and a real estate investor for about 23 years. I've been teaching for over 30 years. So I teach a lot of real estate investors and small business owners and whatnot. Wendy Sweet and I co-founded the Women in Real Estate Mastermind, the Sweetheart Women in Real Estate Mastermind, about 2 or 3 years ago now. And now we've co-founded this Sweetheart Private Lending Institute that we're doing our first one this fall. So lots going on. I've got my private lending company. I've been a lender for 22 years, I think, but I just turned it into an actual company, brought on Patty Bain as my colleague. She's a Class A contractor. You guys had her on the show. And so she's helping me grow this business, and we're super stoked to get it going.
That's awesome. Yeah, I'm so excited as well, especially, the partnership with you and Patty is just an awesome partnership together. So that's great.
Oh, that's great. Uh-oh, I'm frozen.
So, you know what? Last week, it happens. There's a storm outside, so I may freeze from time to time. Last week, we had a wholesaler on, and we were talking about probate deals gone awry. And we're like, how do we prevent this stuff? And I'm like, next week we have Mary on. Maybe we can talk a little bit about passing on properties to our kids, to our grandkids, what that looks like, and how do we prevent the chaos that is probate?
Yeah. So I started out as an estate planning lawyer. That's my passion in the lawyer field. I've also done real estate and business and tax and all that, but I love the estate planning. And I call your estate plan your ultimate love letter because, stopping the chaos and taking care of our loved ones is truly the ultimate love letter if you do it in a way that's less stressful. So probate, I hate probate. Some states make it relatively easy. Some states make it very, very hard. Some counties make it easy. Some counties make it hard. My perspective has changed because I practiced in Alaska for many years, and the probate process was super simple. And then I moved back to North Carolina where I grew up, and theoretically it should have been just as simple, but it wasn't. It was really complicated, and you always got a different answer from everybody at the clerk's office. So I'm a big believer in avoiding probate upon your death, having your estate avoided if you can. And the best way, really, there are a number of ways to do that, but I think the best way is through the use of trusts. Revocable living trust or land trust can also do that. But the reason we go through probate is because we have died with something in our separate name that we own in our separate name. And this is a big misconception because people think that everything you own goes through your will. And that's not true. The only thing that goes through your will and goes through probate are things that you owned in your separate name at the time of death. So not in a trust, no joint owner with a right of survivorship, no designated beneficiary, that sort of thing. So if I own a house and the deed reads Mary Hart and I die, it's going through probate. And it's either going through my will if I have one, or if I don't have a will, then my state legislature has created basically a will for me, which is the order of descent and distribution, who gets my stuff. If, however, that house were in a revocable living trust and I died, it would not go through probate. It would just go according to the terms of my trust. If Monique and I owned it as joint tenants with a right of survivorship, she would have that right of survivorship. So the moment I take my last breath, she would own it automatically. It would not go through probate. So you see the difference? So probate only applies if it's something in your separate name at the time of your death. So to get out of probate, we want to get it out of our individual name, either add it on a joint owner with a right of survivorship. But then if you die, or the first person that dies, no probate, but now the second person owns it in their name. So we might go through probate on the second death, or we put it in a trust and it's just a private trust administration, goes according to whatever you've written in your trust document. No probate.
I love that. You know, you hear so many different, do this, do that. And I don't think I've ever had explained quite that way. So I really love the way you explain that. Is there like a specific type of trust that we should be considering? Because, you know, you hear about, oh, have your holding company, and then you got your LLCs, and you got trust, and where do you, this owns that owns that. So what would be the best structure, if I can ask you kind of that question?
So for estate planning, the most common trust is your garden variety revocable living trust. You hear it as a living trust. It's actually just what we call an inter vivos trust. It's when you set up during life. That's what inter vivos means. You set it up during your life. It is usually revocable and amendable until you become incompetent or die. And so you set up this trust and then you transfer your assets into it. And now, rather than your name being on the title, your name as trustee is on the title. So if I put it in my trust, let's call it the Mary Hart Revocable Trust, my deed would not read Mary Hart. It would read Mary Hart as trustee of the Mary Hart Revocable Trust. That takes it out of probate. So that's the most common one. But any trust is going to avoid probate. So you talk about your title holding trust, your land trust, your paper trust. There are a lot of different names that people use. If you have a beneficiary listed on that trust, whenever that trust terminates, it will pass to that beneficiary without probate. If you don't have a beneficiary, and let's say the beneficiary is your LLC, but your LLC is in your separate name, then your LLC is going to go through probate, which basically means the assets in that trust are going to go through probate because you didn't give it to an asset that wasn't going through probate. Now, let me clarify a little bit. If your LLC is the beneficiary of your land trust, but your LLC is owned by your revocable living trust, you're going to avoid probate because your LLC is one of the assets in the revocable living trust. So how do we do that? Instead of you being the member of your LLC, you as trustee of your trust is the member of your LLC. So just like if I had a membership certificate, instead of saying Mary Hart owns 100% of these, membership interests, it would read Mary Hart is trustee of the Mary Hart Revocable Trust is the member. So I've switched hats. I don't have my individual hat on anymore, which will go through probate. I have my trustee hat on as the member. So that avoids probate. So for me, I try to make sure every asset I own is either passing to someone by a beneficiary designation, like my IRAs and my life insurance or anything else has a designated beneficiary. So if I die, those assets will avoid probate because they'll go to the beneficiary. If I have my house and let's say it's just my house, I'm going to title it in the name of my revocable living trust. If my husband and I own a property together, we usually don't even want to do it as joint tenants because it'll only avoid probate when the first one of us dies. So we hold our jointly held property in a joint revocable trust where we're both in control. And when one person dies, that property stays in the trust for the benefit of the survivor. And then when the survivor dies, that property passes according to the terms of the trust. So to our children, for instance. So I try to make sure that every asset I own is in my trust or in my joint trust with my husband. And so if it's the personal property in my house or my jewelry, I've literally done a bill of sale and I've sold it to my trust for $10 or whatever. So I'll say, I, Mary Hart, hereby sell and transfer all of my personal property located in and around my residence or any other house I own to Mary Hart as trustee of the Mary Hart Revocable Trust, that kind of thing. See what I mean? So I just try to make sure that I don't have anything in my separate name. My cars are in the name of one or more trusts. my houses, my personal property, my stock accounts, my IRAs have beneficiary designation, so I don't have to worry about those. But does that make sense?
That
Now
makes
we're just
total
trying.
sense. Does that include bank accounts too?
Yep. So bank accounts, I have different ways. Some I have joint with my spouse or joint with a child, depending on my goal. But I realize that on the first death, the survivor will inherit all of those accounts. And now it'll go through probate in that person's estate unless they do something like put it in their own trust. That's a risk I take because we don't keep large balances in our bank accounts for that reason. And so most states have a small estate procedure that if you just have, say, like a bank account, it's under a certain amount of money, you can do a very shortened version of probate. But I always have them joint on the first death, and then if they're in the other person's separate name, we hope that it's small enough to go through the small estate procedure. But we could always open them in the name of the revocable trust. You just sign the checks as a trustee instead of as an individual.
Yeah.
And is that something that you have one single trust, or do you have a multiple trust for like different things?
So it depends on my goal. So for my estate plan, I have one trust that's just because I'm in a blended marriage, second family. So I have one trust that's for my separate assets. My husband and I have joint trust that holds. We actually have several because we put different properties in different trusts for different reasons. But we're selling most of them. So we will just have one joint trust for our jointly held property. I have a separate trust for my separate property, and we're about to do a separate trust for him for his separate property.
Okay.
Now, in my first marriage, we were young. We built everything together, so we didn't have separate assets, and everything was together. But that's a little bit different this go around.
So on that one, you just had one trust then?
Yeah. Yeah. In fact, actually, in that marriage, I was so young and we had nothing. I didn't have really anything. I didn't have a trust until finally one day I was like, wait a minute, I do all these trusts for all these people. I probably ought to have my own. So I don't think I set up, I had trusts set up to take effect when I died through my will, but they would not have avoided probate. Once I started accumulating some assets and my kids were getting older, I was like, you know what, I'm going to just do my own revocable trust. So we did, but we just had wills when we were young and naive. But all three of my kids, I have three boys, their ages 25, 30, and 33. They all have a revocable trust. No matter what they have, the littlest thing, their cars are in it, anything else. I'm like, nope, we're starting them off from the beginning, not having to go through probate.
Smart.
Wow, Mary, I am just like, I can't believe that in 10 minutes, you broke that down for us in a way that I have asked and watched so many different things, didn't get it. Like, what do I do? I'm so confused. You tell me to do this. You tell me to do that. And you just broke it way down and had it all nice, put a pretty little bow on it for us. I love that. That was so
I've been doing it for a long time, and I want it to be simple so people don't avoid it, because it is your ultimate love letter, and it's the nicest gift you can give your loved ones is to get your stuff in order, because we never know when we're going to take our last breath. We hope we're old and gray and wrinkled and still sane, but we never know, right? We could still by
some days that's debatable.
And I just had this conversation with my business partner, and he said, you've got accounts that are only in your name. What's going to happen if something should happen to you? And you just answered my question for you. You just answered my whole put our whole solution together, what we need to do. Do we have to go to a church, or can we do this on our own?
Yeah. Well, I don't think estate planning is a DIY thing. I think you need a good estate planning lawyer, because we don't know what we don't know. And unfortunately, legal concepts are not intuitive, and they're not taught in our schools, and we don't know them until we're forced to know them. And so I've seen every single will contest or trust dispute I've ever seen has involved documents that were prepared by the decedent themselves, either through LegalZoom type of program online or a handwritten will. Every single solitary one that I've been involved in has been someone who did not use a lawyer. And I just think we just don't know what we don't know, and we're not taught these concepts, and they're not intuitive. So it is probably the best use of your money. Don't take the Disney vacation with your kids. Give them an estate plan. Give them your estate plan. Give it to them for Christmas.
That you call it the ultimate love letter. Like that is yes.
Do you have
It really is, because let me just finish this one thing. I'm sorry, I don't mean to interrupt.
No,
When someone dies or even becomes disabled and incompetent, the family and the loved ones have enough on their plate with grieving and everything else without having to try to figure out these foreign concepts that we've never been taught. So to me, the ultimate love letter is not just getting the estate planning documents in place that you would go to a lawyer for, but it is putting together your ultimate love letter workbook, which is every piece of information your loved ones would need to manage this stuff, right? What bills do you pay? Especially if you're a real estate investor, what properties do you own? What's on auto pay? What account does it come out of?
Information.
Right. When are property taxes due? What account do those come out of? Who's the property manager? You know, anything you think of. What's my passport number? What's my global entry card? What's my social security number? You know, what are my passwords? Have I authorized my executor or my trustee to have access to my digital life, which is important? Who shuts down my Facebook page? You need to designate a memorial contact. There's a legacy contact, I think they call it in Facebook. And you designate someone who has the authority to either shut down your page or make it a memorial page. And if you don't have that, then it's just out there in limbo land and nobody can do anything with it. Yeah. So there's all that stuff to think about. That's all makes up part of the ultimate love letter. Is just create a giant notebook to leave to your, you know, loved ones what to do if something happens to you. Because if you're like me, and most women real estate investors are, we have a lot of stuff up in our own little brains, and we think we can do it all, and we don't delegate well all the time. And, you know, I've got all sorts of passwords and everything in my head. So who knows how to get into my passwords? So in my estate planning file, I have a sheet of paper that has the master password to my computer and to my phone and to my password app. And then if they get into my password app that's on my phone or my computer, they get every other password they need, because I've got hundreds or thousands in there. But if I change the master password to my phone, my computer, my app, I change that physical piece of paper and put it in my estate planning notebook or my file, so that my, you know, executor or trustee can get to all my passwords.
Yeah.
So I was going to say, it doesn't matter where your property is at.
We can't hear you, Donda.
State. Oh,
yes, I can.
I can hear her.
Okay.
Oh, I can't.
You mentioned though that like each state's different. So when you have a trust, it doesn't matter how it's set up. Each state, the trust is accepted in all the 50 states.
Good question.
So every state has its own trust code law, but they're mostly the same. They're mostly the same. You should go to an estate planning attorney in the state in which you're a resident. That's where you should go. Most of those trusts are going to be the same. And every state, there's something called the full faith and credit clause. Every state has to give full faith and credit, or give effect to the laws of another state. So if you created a trust in Arizona, but then you move to Florida, as long as you sign that trust validly under Arizona law, Florida has to accept it.
Has to recognize it.
Right. Now, I usually tell people, if you do move states, it probably makes sense to buy an hour of an attorney's time just to say, is there anything I should do different in Florida or wherever you move? And the reason for that is not because the state doesn't have to recognize the documents from another state, but let's say it's your power of attorney or your healthcare power of attorney, and you're in the hospital and some doctor doesn't recognize the state form because they're used to seeing a form one way and not the other. It's not that you won't ultimately get it accepted, but what hoops do you have to jump through to make that doctor take a form from out of state? They have to, but they don't know they have to till a court gets involved. And so it's just
that education piece that we just aren't taught these things.
Right. And so it's easier, I think, if you change states, just to pay a lawyer to make sure that they'll be easily recognizable in your state.
Yeah.
So even if your properties you have properties in different states, as long as you focus on you live in, and then if you move, get it updated if necessary.
So let's go through that, because let's talk about probate again. Real property, like houses and land, has to be probated in the state in which it's located. So if those properties you're mentioning are owned by you in your separate name, let's say you've got Arizona and Florida and North Carolina and Georgia, but they're all in your name, Donda, then when you die, your estate's going to go through 4 probates, one in every one of those states, because you've got properties in 4 states. But if instead you either put those properties in an LLC, and the LLC was owned by your trust, or those properties were just owned directly by your trust, no probate. Because remember, it only goes through probate if it's in your separate name when you die. But if it's owned in an LLC, that's not real property, that's personal property. So what you own is the LLC, which is personal property. Personal property is probated in the state you live in when you die. Only real property, the physical real property, has to be probated in the state in which it's located, and that's only if you own it in your separate name, not in an LLC, not in a trust. Now, if you don't put your LLC in the trust, then that LLC has to be probated, but only in the state in which you were living when you died, not in every state for the real estate in which it owns. Does that make sense?
Yeah. Okay.
So the best practice is either to, if you want to hold like me, I have a lot of real property in LLCs. I have multiple LLCs. So those LLCs are owned by my revocable living trust. So, and I have property in North Carolina, Kentucky, New York, Virginia. So I have a bunch of different states. Every one of those properties is owned by an LLC. Those LLCs are owned by my revocable living trust. So when I die, none of that will go through probate. Not the real property, not the LLCs. My trustee, who's my oldest son, will literally just read the terms of my trust and deed out the properties or the LLCs or whatever the way I said in my trust document. No court involved at all.
Perfect.
Yeah. And when you record a land trust, when you have a property in a land trust, you don't record, I'm assuming, a revocable trust.
No, you do not record a revocable trust, and I would not record a land trust. I might record a memorandum of that trust to say the trust exists, and I'm not even sure I would do that. It depends on whether I was required to for a closing or something. One of the benefits of the land trust is that they're anonymous. We don't know who the beneficiaries are. It makes it harder for them to be sued. Lawyers don't want to take on those types of trusts when they sue. So if you record the actual trust document, you're letting everybody in the world know who owns that trust. So I would not do that. The other thing I would not do with a land trust or personal property trust, paper trust, same idea. I would never name an individual as a beneficiary because that breaks the creditor protection. So let's say, Donda, for instance, you ran a stop sign and maimed somebody. They sued you and they got a judgment against you personally. If you're the individual beneficiary of your land trust, they can get through the land trust to get your properties, or vice versa. So it slips and falls on your property, wins a judgment against the trust, but you're the individual beneficiary. There's no creditor protection. They can bop through that trust and get all your personal assets.
Wow.
But if that trust isn't recorded anywhere, how do they even figure that out?
Well, because when you get involved in a lawsuit, there's something called depositions and discovery.
Okay, that makes sense. Sorry.
Aaron Lee, are you beneficiaries of any trust? Who set up that trust? When was it created? Who are all the beneficiaries? What does that trust own? So things are discoverable. Things are discoverable. So, but when you name an LLC as a beneficiary, an LLC, if it is set up and maintained properly, is a creditor protected tool. So if somebody, if we'll go back to that example with Donda, if Donda ran a stop sign and got a judgment against her, that's against her individually, but that LLC would create some creditor protection. They would not be able to take a personal judgment against you, Donda, and get into your trust. Probably not even into your LLC if it's done correctly. So I would never name an individual as a beneficiary of a land trust or a paper trust. Revocable living trust is different, but they're not creditor protected at all. They're just, here's the general rule. If you have control over something, your creditors can get to it, generally speaking. So with your revocable trust or your land trust, if you're an individual beneficiary, because you can, as a land trust, you can direct the trustee. In your revocable trust, you can amend it, revoke it, take assets out, put assets in. You have full control as long as you're alive and competent. That means that there's no creditor protection. There might be some smokescreen or anonymity type stuff, but there's no legal creditor protection with a revocable trust. There are irrevocable trusts that can provide some creditor protection. And if anything's in those trusts, they will also avoid probate. But those trusts, most people don't do those for their estate plan unless they're doing it for one little piece of an estate plan, because you have to irrevocably give away whatever you're putting in that trust. You can't be the trustee. You usually can't be the beneficiary unless it's in certain states that allow what we call domestic asset protection trust, self-settled asset protection trust. So we don't use irrevocable trust very often unless we've got a very specific purpose for it. So your general estate planning trust is going to be revocable and subject to the claims of your creditors.
So does that mean the trustee should not be an individual? It should also be an LLC?
Trustee has nothing to do with it because the trustee has no responsibility for any judgment against you or the trust.
Okay.
They're just a fiduciary. They don't just because their name's on the title, they're not personally responsible. Like if somebody sued your revocable trust and won, they couldn't go get the trustee's personal assets.
Okay. Got it. That makes sense.
So if I bought a house and I put it in a land trust and yet I live in that house, ought to I write myself a lease for that house and leasing it from my trust? Or
is this for creditor protection purposes? Because I don't know that it makes a difference.
No.
Who's the beneficiary of your land trust that owns that house?
The LLC.
Okay, so the LLC the trust could rent you the house, but again, it depends on who the judgment's against. If the judgment is because, you had a guest over and they slipped and fell in that house, they're going to sue your land trust. And if they win, they're going to get the equity in the house. Doesn't matter that it has a lease. Now, if you had, let's say you'd taken out a loan against that house, like a line of credit, and you put a $300,000 debt on that house, you literally used that line of credit, well, then you have less equity that creditors can get. But it's very hard to do in two steps what you can't do in one. To avoid creditors, there's certain things. LLCs are more creditor protected. They have state law creditor protection in most states. Some states have eviscerated the single member LLC as far as creditor protection, like Florida is one of those.
Did she freeze? Or
sometimes
Mary's frozen. There we go.
You froze there for a little bit, Mary. Oh,
steps, what you can't. Am I still frozen?
Hold on.
No.
I think you're going now. I think you're good now.
Yeah.
Can you see me now?
Yeah.
Yes.
We just couldn't hear you.
So,
Mary, we got Florida, single member, eliminated that, and then that was where we cut out. Go ahead.
Yeah, so you have to check your state law to see whether they give full creditor protection to single member LLC. But let me tell you a little bit about why LLCs are better than, say, corporations for holding real estate. Well, forget the tax reasons. I'm not going to talk about that. But from a creditor standpoint, if I have a state that allows what we call charging order protection, if someone sues my LLC or sues me, let's say they sue me as the member and they win, what they get is a charging order against my LLC. And that charging order just sets them in my shoes. So they can stand there with their hands out and ask for a distribution. But if my LLC doesn't distribute to me, they don't get anything. They just step in my shoes. Whatever I'm entitled to, they get. That's a charging order. As opposed to a judgment, say, with a corporation where that person could literally step in and vote my shares in the corporation and liquidate all my assets and make a distribution and take money. So corporations are not as creditor protected as LLCs if you're in a state that allows full charging order protection. So we see a lot of, and also LLCs are generally better to hold real estate than corporations because corporations have all these tax rules that make it hard to get the real estate out. And we won't go into that in detail because I haven't looked at those rules in a while and I don't want to steer you wrong. But that's a good CPA question. And in general, we hold real estate in LLCs and we run operating businesses out of S Corps or LLCs taxes S Corps. And that all has to do with taxes, self-employment taxes, all sorts of things like that.
Right.
So that's a bigger conversation than we need to get into tonight. It'll just confuse everybody.
We're already halfway through.
Talk to your CPA when you're deciding what type of entity you want for creditor protection and tax benefits.
Well, and if you have an entity like an LLC in one state, like, I don't know, Vegas or Utah or Wyoming or something, but you have the property in a different state, but you're not doing business, it's just holding that property in a different state. And then that state, you're refinancing, that state says, somebody says, we want you to do a foreign entity register. Is that a wise thing to do, or is that something you want to stay away from, or is it?
Well, I personally set up my LLCs in the states in which the property is. It's
Okay.
just simple. It's governed by that law. If not, then you have to look at the state's law to determine what is considered doing business in that state.
Yeah.
For instance, in my lending company, I'm just made my first loan in Texas. And I was like, wonder if I need to go register as a foreign entity in Texas. So I read some of the law and I reached out to an attorney there. And if I don't have any employees there, I'm not soliciting there, I just am servicing a loan there, that's probably not enough to be doing business. So I probably don't have to register as a foreign entity. But if I put an office down there with an employee, or I start advertising in Texas, hey, you Texas people, come borrow from me, then that's probably going to put me in the doing business in that state, and I'm going to have to file as a foreign entity. So, there are a lot of people who go to Nevada, Wyoming, Delaware, because they're corporation friendly states. They have lower filing fees, whatever. I usually, I don't try to, how do I say this without sounding weird? I don't let the dollar wag my tail.
Yeah.
I try to be efficient and all that, but I'm not going to make my life overly complicated to save $200 a year.
Yeah.
I'm just not.
I love your saying, wag my tail. I don't let it wag my tail.
Well, I used to say, I don't let the tax, whatever, the tax something wag the dog's tail. I can't remember what I said. I used to have a saying and it's gone now. But anyway, it's late and I didn't sleep last night. But anyway.
I like to wag your tail. It's fun.
I want to make smart decisions, but I don't want to end up chasing every little penny and being foolish with what that does to my life. So penny wise, pound foolish, but also penny wise and lifestyle foolish. I'm personally not going to do that. Now, when I was practicing law, I realized there are people on every end of the spectrum. There are clients who wanted the most complicated, most expensive, most protective estate plan, for instance, and they didn't care how tedious it was. And then there are the clients who didn't want to pay any money, wanted the simplest thing, and whatever. And everybody falls somewhere on that continuum when it comes to how they structure their businesses. And for me, I try to balance it between being, penny wise and not overcomplicating my life. So I just set up my LLCs in the state in which the property is located.
And I think for the most part, the cost to register an LLC and even the manner in which an LLC is formed is a simple form that's usually readily available on the SEC type website of whatever state you're in. And it's, $100, $150, $200 for the year. And it's done, and it's so simple. And I think that, a lot of people make it out to be a lot more complicated than it really, really, truly is.
Yeah, and I think that's right for many states. There are some states, like last time I looked at California, it was $800 a year, right?
Exactly.
So if you have 10 LLCs in California, that's a lot of dough you're paying to California.
Exactly, yeah.
So then I could see, all right, do I have a Nevada holding company or whatever? And you can certainly do that. There, even with.
She froze up again.
That's okay.
Yeah.
I have a full signal. I'm not sure.
It might be me. It's the way, because it passes through my.
Oh, it might be
from you to me. So you're muted again, but give it 1 second. It'll probably reload. California. There you are.
Yeah, California is expensive. So if you're doing lots of LLCs, then people want to do something different. But and I just think that, again, it goes to people's personality and what their business structure is, how complex they get and what they choose to do. But I think that people should consult an attorney and a CPA that's knowledgeable about whatever they're trying to do. Those are the two professionals that I think are very important, and a good insurance agent. And I hate that we have to use insurance, but I think if you're going to use insurance, you need a good insurance agent.
I agree. So let's do a quick little pivot, because you're talking about, finding the professionals in whatever you're doing, right? And insurance and CPA and attorneys and such. You did a wonderful talk at Dealmaker this year about due diligence. and
Yes.
vetting these professionals and vetting these people. And that's a wonderful pivot into your lending business too, right? Vetting borrowers, but borrowers vetting the lender as well.
Absolutely.
Talk to us a little bit about, vetting a professional. How do we find a good insurance agent? How do we find a good CPA or whatever? And then, go ahead.
So they're anybody can advertise on the internet. So it takes more than just somebody's good marketing, because there can be really bad professionals who have a great marketing team and really great professionals that don't have any marketing team. So I do not rely on the marketing to say whether they're good or not. I was looking for an attorney in Missouri for some loan documents. So there's a website for lawyers called Martindale Hubble. I think they also have lawyers.com. And they rate lawyers. And so I went on there first, and I'm looking for the practice area and the state, and even down to the city that I want a lawyer in. So then I found, about 5 different firms, and I go on their website, not for their marketing, but to see what practice areas, what experience each lawyer has in that practice area that I'm looking for, all that. Once I narrow that down and I start making phone calls, whether it's to a lawyer, a CPA, a doctor, what would you ask your cardiologist? You wouldn't say, have you done any kidneys? You'd say, what do you know about the heart? What do you know about the heart? If I'm a real estate investor, I'm going to say, what do you know about real estate? What do you know about land trust? If I'm doing my estate plan, how long have you been an estate planning lawyer? What size of estates do you usually set up? Are you doing estate plans for people that have $10,000 or $10 million or somewhere in between? So what is important to you, and ask those questions. Just like you'd vet any and I always take it back to the doctor, because we always go like, oh, we need the specialist. We need the cardiologist, the gynecologist, the dermatologist, all those IST names, right? And I have a funny story about that in a minute. But anyway, so you'd look for the specialist. So whatever it is you're looking for as a lawyer or CPA, find the lawyer that does that and does mostly that. So people used to not hire me as a lawyer for, say, a closing, because they could get it cheaper for $25 cheaper down the street. And I'd say, well, do they do closings? No, they're a family lawyer, but he said he could do my closing. I'm like, you're going to save $25 by using a guy who doesn't even do real estate closings? Are you crazy? It's kind of like the LLC fees. It's like, do it right, and the money will come. You don't need to be worried about that. The IST story, I want to tell you about that. When I was growing up, I had 3 step siblings, and as we all got older, they were, I won't say the names, let's call Jones, and then we were the Harts. And so all of those siblings, super bright, and they all went into sort of charity things, or educational things. So we had a brother who's an ornithologist. We had a sister who was a lobbyist. We had another brother who was, what was he? Something with an IST. And then all us Hart children, we were lawyer, banker, stockbroker. And I sometimes, one day, realized, if you have plenty of money and smarts, you can be an IST, like a cardiologist or dermatologist. If you got to work for a living, you got to be an a banker, a lawyer, a stockbroker. That's my funny story. One day I was just like,
that's cute.
So I'm an other people are ISTs.
That's why I'm a wholesaler.
Yeah, exactly. We have to work. We have to work.
That's right.
Workers. We are workers. We're not.
I love it.
It's a joke at the time, but anyway. So I don't know if I answered the last question.
That's fine. That's the beauty of this show. We just keep rolling, and wherever conversation goes. So tell us a bit about Fair Oaks Funding, how y'all got started, where you guys are at now, what's going on.
So I became an accidental lender about 22 years ago when someone asked me to do a hard money loan. And I had some cash sitting around at the time, and I said, sure, why not? And then I realized, wow, this is a pretty cool gig. So I did a few of those loans, and then I got busy running my law firm, and I didn't do a whole lot for a few years. And then people started asking me again. I started teaching at these conferences like Dealmaker, and borrowers started approaching me. So I did a lot of lending, just me and a little old Excel spreadsheet. And in the meantime, Patty became one of my biggest borrowers. So last year, she and I did $5 million together. She did $5 million worth of projects that I funded. And at the end of the year, I was thinking, okay, I'm about to turn 62. So I'm like, I'm either going to just retire, which is so outside of my personality, or I'm going to ramp up this lending business. And I started thinking about it, and I realized that in 2024, I had funded over $7 million worth of loans, just me and a little Excel spreadsheet, no software, no help, no nothing.
That's
And
cool.
Patty is not only my biggest borrower, but she is a business partner of mine. We own a bunch of vacation rentals in Richmond together. And so right about that time, I started talking to her about, I think I really just want to ramp up this lending business. And she started saying, I'm really getting kind of tired of flipping in Richmond. I was like, do you want to come work with me and let's grow this lending thing? And she's like, yeah, that sounds great. So in November, I was at a hard money lending mastermind in Austin, Texas. And I decided after conversations with Patty, yes, I'm going to do this. So I set up Fair Oaks Funding LLC and said, Patty, let's finish up your flips and come join me. So as soon as she started getting her last flips on the market, she started helping me out with Fair Oaks Funding. And now we're doing it together and it's great fun.
And you stole my margarita partner.
Yeah, she's moving to Asheville. She's at my farm in Kentucky. Well, right now she's traveling, but she's been watching my dogs in Kentucky while I've been in Asheville working on my renovation here. Then we'll get back together. Forward to that. We'll be working side by side every day, which will be.
Oops.
What is? Am I frozen again?
No,
No,
we
you're good now. Okay,
couldn't hear you that last part.
Oh, I said I'm really stoked for this business because we just committed to our first commercial loan of $1.75 million loan.
Wow.
Nice.
Big one. And we've got two other investors who are coming in with us. They're super stoked about it because we're going to make them some good money. And then if you add that with what we've already done or committed to, here we are in late May, and we're already over 4 or 5 million in loans. So we're super excited. Our goal for this year was 8 million as we're getting started, and I think we're gonna blow that out of the water. So
Awesome. Are you
When
guys
people-
lending in every state? Sorry.
No,
what's
go ahead.
that?
Are you lending in every state?
No, not every state. So we're kind of growing organically, in part depending on where our borrowers want us. In my perfect world, we would stay Virginia, North Carolina, South Carolina, Tennessee, maybe Georgia, driving distance from North Carolina. So far, we're lending in Virginia, South Carolina, Mississippi, Missouri, Texas. I think that's where we are now.
Not within that
Well,
small range.
organic. Yeah. So what happens if a borrower calls us and says, hey, we really like you guys. Will you loan in Texas? We just did a loan in Texas. And so, well, we're not in Texas yet. Let me look into it. So I look at the laws. What are the lending laws like in Texas? What's the market look like? Where they want us to loan? And we just sort of assess it and we'll say yes or no. There's some states that make it much harder for lenders than others. And so those states, until we grow bigger and I have more staff, I'm not going to loan in because it's just too hard. So we're just growing organically. We'll see where people want us. And if we want to be there, we'll do it there.
Got it.
Nice. Do you have a
Oh, Sharon, you're
Now Sharon's frozen.
fund or if
Oh, do I have a fund? No, not yet. Not yet. So
Okay.
we don't want to start a fund until we've got the loan volume really clicking along. So
Okay.
what we're doing now is we're taking it, essentially it's co-lenders, but and this is evolving. So for now, I have 2 investors I'm working with right now, and I'm writing them a promissory note. So Fair Oaks Funding is the lender to the borrower, to the flipper, for instance. And then I write my investor a promissory note. So I have the first lien position in Fair Oaks Funding, but Fair Oaks Funding owes the co-lender. And we always go in at least 50% on every loan. So we're never going to probably be under 50%, just because I don't want to be accused of brokering. I want to make sure, I'm trying to make money for my own self as an investor. So one of my investors is one of my trusts, is one of Fair Oaks Funding's investors. My sister and her husband are an investor, another friend's an investor. We've got people seeking us out. We just had a woman yesterday commit to $500,000 towards a loan. This is a former client of mine at Hart Law. And I said, I don't have my structure set up yet beyond just giving you a promissory note. She's like, I'm fine with that. I'm like, okay. There you go. And I think that's because people know, like, and trust me. I'm never gonna let anybody not get their money back. I will eat macaroni and cheese and live under a rock before somebody does not get their money back from me.
Yeah.
I wouldn't. Yeah.
Yeah,
That's
I'm the
why I
same
never
way.
had money for 20 years.
Yeah.
You know, everybody said, well, can I invest with you? I'm like, no, because I don't want to invest this money. But now that we're doing this as a business, we're like, how many people can we serve? Not just the investors that we're trying to help them succeed, you know, the flippers, but the borrowers, but how many investors can we help make a passive return on their money and have it a win-win for everybody? A win for Fair Oaks Funding, a win for the borrower, and a win for the investor. So when we looked at it like that, how many people can we serve and how can we serve them best? Then it became easier to take on investors.
Nice.
Yeah.
That's good. I'm glad to know that you will, you know, entertain a smaller dollar investors that know, like, and trust you, that say, hey, can you just start to grow this for me?
But, and we're trying to figure that
I
out.
love that you have a fund coming soon. So we'll definitely.
Well, not soon. I didn't say soon. We got to build up our volume.
I'm pushing you.
Bigger.
We've talked to the lawyer about it. We know, we think we know what kind of fund we want to set up. But we don't want to put the cart before the horse. We want to make sure that this business is growing organically, sustainably, that we are taking care of everybody's money and taking care of our borrowers. We're not overworking ourselves. And so we're trying to grow this reasonably, not jump in with 6 feet at once, you know, just trying to do it right.
Love it.
So you mentioned a private money institute. Is that something that it's like a classroom type of thing, or?
Yeah. So Wendy Sweet, do you know Wendy Carolina Hard Money? She's been a lender for over 20 years. I've been a lender for over 20 years. And we started to see a need to teach people how to be private lenders, because we're seeing a lot of people wanting to get into that space, which is a great space to be in. I love it. And everybody needs money. So there's plenty of room for lenders. I don't have a scarcity mindset at all about competition. But Wendy and I basically wanted to make sure that people do it right. And so we decided to do a 3-day intensive private lending institute. And it will be Wendy and I teaching for 3 solid days. We're doing it at a large house in the Outer Banks of North Carolina. We can take probably up to 20 people, plus if they want to bring their spouse or something, that we can, you know, bring more people. But we will spend 3 days together, learning together, eating together, hanging out. So it'll be a brain trust for 3 days. Sharon's been to the Sweetheart Women in Real Estate Mastermind. It'll be like that, Sharon, but instead of hot seats, it's education. So it's front of the room education. We're probably after dinner going to have a 2-hour Q&A session every night, optional for anybody who wants to come, because I know it's going to be drinking from a fire hose and people are going to have a lot of questions. Yep. And then we are drafting a nice substantial manual that everybody will be able to take with them. And it will be A to Z of lending. You know, we started outlining the outline of our manual. We're like, man, no wonder we're busy. We do a lot of stuff. But I think it will be really helpful for people who are either new to lending, want to get into lending, or just want to maybe scale up their company. They've been doing it themselves. And they just want to scale it up. So that, if people want to know about it, it's October 2nd to the 6th of this year in the Outer Banks. And they can go to sweetheartmastermind.com. I see it up there on the screen. And you can find out information about the mastermind, the women's mastermind, and about the Private Lending Institute. The institute is for men and women. The mastermind is just for women.
And at this institute, is it going to be recorded? Are you going to have like after support, or is it like, this is just a 3-day thing, we're done, not live all that?
Right now, the 3-day thing, we're done. But what we're hoping to do is start recording some evergreen videos that if there's enough interest, then we would have a membership that people could come on, and we'd have not only recorded videos about everything about lending, but we'd have ongoing Zoom calls, Q&A sessions, you know, working with us. That's not going to be part of the Private Lending Institute itself, because we haven't baked that into the tuition. You know, the tuition just literally is covering the venue and the food and the beverages and a little bit of swag and the manuals. So that the ongoing stuff is not counted in that. But if there is interest, we've talked about being willing to do more of a membership learning, ongoing learning.
I love it.
Yeah, that would be phenomenal. I think you find a lot of people would be very interested.
Yeah, and we have had people kind of ask, and that's why we started thinking about it. But we'll see how it goes. We're still filling up the first session. This house, we've rented it for 2 weeks, so we have the first Sweetheart Women in Real Estate Mastermind session for September 28th to October 2nd or something like that. 29th to 2nd, I can't remember. Then we have the Private Lending Institute, and then we have the third session is supposed to be the Women in Mastermind. But we'll see which one we get more interest in. We're still filling up the first session for both the Mastermind and the Lending Institute. So that third session is kind of fluid right now. We'll see what people want. We could either do another Lending Institute or we could do the Women Mastermind, depending on what we get the most demand for.
I love it.
Yep. And I told Wendy, if we get no demand, then she and I are just sitting on the beach for 4 days.
Heck yeah.
We'll all come join you.
Right. Anyway.
That's awesome.
Yeah.
Well, cool. Ladies, do you have any other questions for Mary?
We could talk all night. There's so many things to talk about.
I know.
Oh my goodness.
What's next?
Let me go back to one thing. You talked about my keynote speech at Dealmaker on due diligence and not only vetting professionals, but let's talk about the lenders and the borrowers. All lenders know they have to vet their borrowers, but most borrowers don't vet their lenders. And I think every borrower should vet their lender because there are a lot of sketchy fly-by-night scammers out there that are posing as lenders. And one thing I want people to know, people always ask me, well, how do you spot those people? Well, one, if they're asking you for a lot of money up front before the closing, send us, $1,000 underwriting fee before we get to closing or whatever. Some of those are legitimate, but if you get a lot of those fees, run, because they're probably not legitimate lenders. They're probably going to take your money and you'll never hear from them again. The other thing I think people should be aware of when they're vetting lenders is making sure if they're talking to multiple lenders and they're asking about rates and terms, that they're comparing apples to apples. Because let's say I said, okay, our rates are 12.99% and 3 points. And they vary, by the way. I'm just making up numbers. 12.99% and 3 points. And let's say somebody else was a lender and said, well, I only charge 10% and 2 points. And so that borrower says, well, I'm going with the 10% and 2 point person. That sounds great, but they never asked what other fees the 10% and 2 point person lender had. So maybe we just have a tiny underwriting fee and a wire fee, maybe an inspection fee, but they're all, minimal. But then you'll get these other people. We have a $2,000 underwriting fee and a payoff fee and a demand fee and a this fee and a that fee. And it's just all these junk fees that by the time you get to the end of the loan, you've paid way more than what you would have paid Fair Oaks funding, for instance. So for anybody out there, and I'm not trying to sell Fair Oaks funding, I'm just telling people as borrowers, vet your lenders, make sure they're legitimate, check the Secretary of State's office for their entities, ask the right questions, check their fees, ask for a list of everything they're going to charge you. Don't just go off interest rate and points, because a lot of times there are things that aren't disclosed till you get to the closing table and all of a sudden you're out a lot more money than you think you are supposed to be.
That's a great tip.
Very good points.
Yeah.
Really good points.
Yeah.
I don't think anybody really thinks about that. They're just thinking that they're helping them and they don't want to rock the boat, or they don't think that they have the right to ask those questions.
And everybody should ask any question they want. I tell people when I teach all the time, there's no such thing as a stupid question. If you have a question, by definition, it is not stupid, right? Ask the question and don't worry about looking silly. Don't worry about offending anybody. If you ask a legitimate question, any question, and that offends the person and they start going, well, I thought you were sophisticated. Why do you need to know that? What do you mean you can't act quickly? That's them that's them scamming you.
Yeah.
That's them making you feel bad to get what they want. And you need to run from those people, because a legitimate lender or a legitimate anybody is going to welcome your questions and say, what can I do to reassure you? I am an open book. I'm transparent. What do you want to know?
Yeah.
And if you run into someone who doesn't treat you that way, do not do business with them. That's my tip to you. Do not do business with them. They are gaslighting you. They're not good people to deal with.
Yes. That goes for relationships too.
Where do you think I learned it from in the first place? Yeah.
Yes, ma'am.
That's for a reason. Remarried for a better reason. But anyway. No. I'm half teasing, but just don't ever be afraid to ask questions. Yeah. Anybody who's listening to this, don't be afraid to ask questions. We should all ask questions. And, nobody's going to protect your money, your reputation, or your time like you are.
Yeah.
Nobody.
Yeah.
Right.
No single person. And your integrity and your time are so very important, and your money is so very important. And you should never feel bad about doing everything to protect that. Right?
Yeah, and asking those questions is so important. And I totally agree with you. I've come across where lenders are, unwilling to disclose like all the fees, for example.
Yeah,
Well, it's just this. You shouldn't even worry about it. Well,
yeah,
I am
crazy.
worried about it because my bottom, or they won't give you an actual quote. I've got something under contract. I need an actual, a commitment letter that outlines all this stuff. And they're just like, well, you're approved. We'll fund it. Okay. But I need numbers. That's my business name is Number Crunchers. Like, I'm a number girl. Give me numbers, And I'm
you're exactly right. I mean, when we always have the conversation, and we know whether we're talking to the borrower, are we going to fund this or not? But as soon as we all come to a meeting of the minds on the phone or on a Zoom call, my next step is sending a commitment letter. And I lay out everything that we've talked about in great detail. In fact, this commercial loan we're doing, I think I just sent them a 3.5-page one because I wanted it very clear, every single thing. Now it's bullet pointed paragraphs. It's
that's
lots
great.
of spacing in there so it doesn't confuse people. I hate it when you crunch all the lines together and make it hard to read. So I spread my stuff out. But anyway, and I always say, hey, this is what I think we've agreed to. Please read it carefully. If you agree, sign it and send it back. If you don't agree, then let's get back on the call and find out where we miscommunicated, and let's make sure we're on the same page, because there's nothing worse than getting into a loan from either side and find out you weren't on the same page. There was no meeting of the minds, and now everybody's mad and you're fighting, and you're going to cost more in lawyers' fees than anything else. So I want it as transparent as it can be from the beginning.
I love
that. And with AI these days, it'd be so easy to have that conversation on a Zoom, and then summary, and you can literally just put that in a 3-page, document, or how many page document, page, whatever that looks like, and shoot that off, and just do like a quick edit and shoot that off to somebody. That makes total sense. I just had a completely different, not private lending, but just a different conversation with a contractor of ours that's going to do some different things with us, and I love that. I can use that kind of a concept in the same way,
Well, I think this is my lawyer background too, because in advising people to do, whether it's operating agreements or buy-sell agreements, it's like the more you can put everything on the table up front when you don't know whether you're going to be the aggrieved party or the aggriever. Well, I don't know if that's a real word, but you know what I mean? Before there's an argument, put everything in, as much information as you can, fully transparent, to make sure everybody has that meeting of the minds. Because a lot of times we talk about things and we hear differently than what the other person is really saying. But when it's in black and white on a piece of paper, it's like, wait a minute, that's not what I thought you said. Well, let's go back and rehash that and make sure we're on the same page. And getting it in writing is what allows people to take a look at it in a quiet time when they're not on a phone call and say yes or no, that's not what we agreed to.
And you avoid so many miscommunications later on when you're down the road and you still care for the person or like the person or whatever that looks like. And then all of a sudden you're hitting heads. And it's like, if you had that communication, then you can continue that communication in that manner.
And I think that's really important too, from a borrower standpoint. I've had borrowers go silent. My clients have had borrowers go silent. And that's the worst thing somebody can do. Like, we consider ourselves consultative lenders. We want to know the moment our borrower starts feeling stressed that something's going wrong, because we can probably step in and help. Patty's got so much flipping experience, hundreds and hundreds and hundreds of houses. I've got so much legal experience and so much just investing experience and so much knowledge from teaching for 30 years. And so when a borrower goes silent, that's a big red flag to me. And we're trying to reach out. And if they ghost us, they're just shooting themselves in the foot, because we could probably help them with a problem that might seem overwhelming when they're in the middle of it. And we could probably help. Right. So if you're anybody, whether you're borrower, lender, contractor, if anybody starts feeling overwhelmed, communicate.
Right.
Yeah.
I love it.
I do too.
I love it.
Good.
We are at the hour. See, I told you it goes fast. Every
It
week
goes
we
very
run out of time.
It goes very fast.
We gotta have
You're
Mary.
an
thank you
amazing
so much.
guest,
No.
Mary. Thank you.
Thank you for having me. It was a great conversation. I love to talk about these things, so thank you.
It's cool.
Absolutely. And everybody, please do, if you have things, push Mary to be lending in your states, not just ours. And go hit up there. Hey, if I am a borrower and is there like a quote page on there, or is it contact us, or how's that?
So well, the easiest is to email borrow@fairoaksfunding.com. So that's just an email. We're just getting our website. It's just got pushed out, I think, in the last couple of days. And I believe there is a Get Funded Here button that will take you to the right contact form. Allie Murphy, our marketing guru, is working on that for us.
She's the
Well,
best.
she actually has joined Fair Oaks Funding doing our marketing and our COO stuff, so she's helping us out. But I don't want to speak out of turn. I think it's ready to go, but even if it's not, you can always email borrow@fairoaksfunding.com and get to that. Goes to Patty, and then if she needs me, she pulls me in. But Patty's sort of the first conversation with the borrower because she is a borrower herself, so she knows the lingo.
So
She's
people
Borrow or borrower?
Borrow, just
okay.
borrow. No ER at the end, just borrow. Borrow at, yep, right there, Fair Oaks Funding, borrow at. And if you want to be investor, you can email invest@fairoaksfunding.com and you get to me. So I'm the investor relationship manager, and Patty is the borrower relationship manager.
That makes it
We
nice.
both get involved in everything for the most part, but at least the initial communication is to Patty if you're a borrower, to me if you're an investor.
I love it.
or at least
There you
look to lend, have you be our lender,
Borrow and invest.
vetting and asking questions, correct?
Yes. So if you get me like at invest@fairoaksfunding.com, we'll just schedule a call to see what you're looking for in terms of passive returns. Can we be a good fit? Are we not a good fit? We just go from there.
Yeah, perfect.
No obligation for either of these if you email us. They're just the start of a conversation.
Exactly. Awesome. All right. Well, I'm going to go ahead and say good night, YouTube land. Good night, ladies. Mary, thanks for coming on. We appreciate it.
Thank you so much.
Thanks for having